Hello, and thank you very much for being part of today's program. Let's talk right here on Love World Plus. My name is Zoe Okafor, and today we will look again into the crisis currently rocking the River State, that's in South Nigeria. Now, the Nigerian legislative process seems to have come under intense crisis of confidence with the recent political drama that played out in the River State House of Assembly. Now, this is in addition to the series of crisis events that have rocked the state because of political conflicts involving the governor, Rotimi Amechi, and perceived political enemies. Now, the questions we are asking is, what should be the way forward? These and more in this particular edition. Now, to help me look at some of these issues, I am joined this morning. Please give me a minute. All right, I'm joined by Taiwo Adedeji, who is a legal practitioner. He also is a consultant as well as a policy analyst. You're welcome to Let's Talk.
It's my pleasure.
Okay, now, I mean, if you watch the news, it is very likely that you're going to see one story or the other about the crisis currently ongoing in River State, especially with the scenario that we witnessed, the violence that we saw displayed by the honorable members of the State House of Assembly in River State. First of all, I really want to know what was your reaction when you witnessed that particular incident, because we're going to go on from that point.
I think my reaction is not more than the reaction of an average Nigerian who observes over the time the trends toward violence in the legislative houses of assembly that we have. The River State, that has been the epicenter of this violence at the moment, has actually brought this issue to the front burner again. The issue of physical assault and violence by supposedly honorable members of the Houses of Assembly. And it is quite unfortunate that it happened. And in fact, without being uncharitable, it's a national embarrassment that we have to witness that kind of ugly incident in the River State of Assembly. Though it have been occasioned by certain things that even beyond what is being presented in the media. But the reasons are not far-fetched. They are obvious facts. So.
Okay, now as a legal practitioner and speaking from the position of the law, what really transpired there, legally speaking, whether against it, whether blatantly, disregarding the law, the legal institutions, by what happened in the House?
First and foremost, from the standpoint of the law, what happened there was a display of lawlessness and brigandage. Because the law is very clear, both the Constitution and the Legislative House of Government Act, that empowers the legislators to function properly. The law is clear as to the role. Constitutionally, what happened there, occasioned by the attempt by a group of lawmakers who are obviously in minority to impeach a speaker of the Section 90, Section 90, Section 91, and Section 92 of the Constitution are very clear as to the procedure to follow in removing a speaker from office. And it is very obvious that the least required is that it must be a decision by the majority of the members of the House. So in a 32-member House of Assembly, you cannot say 5 members are in the majority. So it's a display of lawlessness. The very attempt in itself is felonious. If we are to be in a climate that where laws are enforced, are implemented and enforced to the letter without fear or favor, those members of the House of Assembly ordinarily by now should be the 5 members. Now I'm not even going to the physical violence. The 5 members that attempted to impeach the speaker, they should have been charged with treasonable felony by now.
What do you think gave them the boldness or the audacity? What made them think they could actually do that, 5 of them, and get away with that? Is there anything, maybe past antecedents or something that suggests that 5 people or someone can just wake up one day and go and overthrow the speaker of a house?
Yes, yes. Both, first and foremost, past the antecedents. Actually, because if a bad president has been laid, it's the kind of, it gives people, it gives those who are involved the encouragement, to drive, to be driven more towards that kind of trend. Like we have in the most recent past, during the Obasanjo administration, where 4 members, or is it 4 this time, or 6 then, the Plateau House of Assembly incident, before it was later invalidated by the Supreme Court, when just about 6 members were trying to impeach a governor, a sitting governor of a state. Then, also, the one that happened in Oyo State, when a group of lawmakers who were less than the quorum required to remove a governor actually impeached a governor, and that impeachment was recognized by the federal government. So in this case, Rivers State, what gives them the boldness, we should not shy away from the truth, is that the Rivers State of Assembly crisis has been instigated from the outside. Okay. And that is what can give a 5-member, in fact, they should have even be afraid that they can even be consumed in the ensuing violence. If not, what audacity will a group of 5, now 32 members House of Assembly, now 5 against 27? Ordinarily, if not because they were emboldened by some external forces, there is no way, it's going to be suicidal for 5 people to want to confront, whether lawfully or unlawfully, a House of Assembly dominated by 27 members as opposed to 5. So it has been, to me, without shying away from the truth, this crisis has been instigated not from Rivers State, but from outside the Rivers State, and that is what gave them the boldness. And
to even do that in the first place. Okay, well, if you're just joining, we are looking at the judiciary and political conflict resolution in Nigeria, and we're focusing particularly on the Rivers State crisis. I'm still talking with Taiwo Adedeji, legal practitioner and consultant, as well as a public policy analyst. Now, some experts say that Nigeria's political terrain is really lagging behind, especially as it regards dispute or conflict resolution through the judiciary. What is your take on that?
Well, my take on that is that, you see, the judiciary is not going to be a meddlesome interloper. Judiciary will not meddlesome into an affair that has not been presented. Judiciary only acts on what is presented before it. So we have to have that at the back of our mind. Okay. So it is a kind of, judiciary is supposed to be, it's not political, it's not partisan. So it is only when cases are presented. So to me, it's going to be a vague description, though maybe when we talk about resolution of electoral issues, we might say, to a very large extent, judiciary appears to be lagging behind. But then, to the extent, the constraint is not even in the judiciary as such, but the law that sets up some of these institutions. Like, for instance, in an attempt to checkmate people who are not lawfully elected from almost spending the tenure of the legally elected governors, like we had in Osun and Ekiti State. Now, the wise men that amended the Constitution, quote unquote, now put a situation where even election petitions will not linger on for more than particular days, 180 days. Now, that in itself has created a kind of avenue for those who believe only in technical justice to get away with that. So to that extent, it has not even checked rigging and electoral malpractices. What now happens is that after someone has frustrated the hearing of a petition, technically, the person will now go to court and say, this thing is time bar, it's statute bar, you can no longer proceed. So most of the cases that have been decided in the present dispensation have not been decided on merit, and it's quite unfortunate. So, but before we blame the judiciary, we have to look at the provision of the law. The judiciary can only act within the confine of what the law says as regard things, and those things, if those are not presented before the judiciary, there is, in fact, the hands of the judiciary are tied.
Okay. All right, what about the issue of immunity? I'm sure that somewhere in the back of their minds, apart from the fact that, like you said, that probably their audacity and boldness might have had to do something with the fact that there were external influences. What about the fact that they have immunity to some extent because they are sitting lawmakers. So to some extent, they have some sort of immunity. Now, there have been calls for the prosecution or at least punishment of some key individuals that were responsible, especially the ones that were seen to have started the violent conduct, you know, like using the mace to hit somebody and all of that. What about that angle of the law? You know, from your position, what has to happen now? How do we address what happened in that place?
First and foremost, you see, from the standpoint of the law, it is not correct to say that legislators enjoy any immunity from criminal prosecution. As a matter of fact, if you look at, I think, Section 21 of the Legislative Arms of Government Act, Establishment and Empowerment Act of the Laws of Federation 2004, actually provides for instances where, in fact, prohibits the conduct that we witnessed in Rivers State House Assembly, because that law clearly states that no member has a right to assault another member, even if you have done so within the confine of the House of Assembly. So you cannot participate in the criminal conduct and now under the guise of immunity. They are not immune from criminal prosecution, and that is very clear, and it should be at least